You're watching Reality Check. Outrage is rising over the arrest of a 22-year-old environment activist, Disha Ravi, picked up from her home in Bangalore on charges of sedition for her supposed role in drafting a toolkit document for the farmers' protest. The police have defended the manner of and reasons for her arrest. They claim they arrested her from Bangalore in the presence of her mother and local police officials. But they did not, contrary to several legal precedents, get permission from a local court. The Delhi High Court, for example, in a 2019 order has said that the endeavour should be made to obtain transit remand after producing the arrestee before the nearest magistrate, unless exigencies of the situation warrant otherwise. What were the exigencies here? We don't know. There are also questions over why her own lawyer, the Delhi-based Abhinav Sekhri, could not be present while she was produced in court and instead was given a stand-in government lawyer. Undeterred, the police say they are attempting to arrest two more individuals associated with this farmers' protest document: the Mumbai-based lawyer Nikita Jacob and a Beed in Maharashtra-based activist Shantanu Muluk, an engineering graduate. Nikita, who the police say is missing, has sought anticipatory bail. But what's the evidence against all of them? The police claim all three were crucial in drafting, editing and sharing a toolkit document for the farmer protest, a document that Disha reportedly sent to climate change activist Greta Thunberg and which Thunberg tweeted. But since the police first red-flagged this toolkit, we still don't know how this document, which contains no incitement to violence, adds up to sedition. It only contains the standard ingredients of protest mobilization, from planning a Twitter storm to petitioning local politicians. The Alt News founder Prateek Sinha has shared documents which are toolkits for Twitter storms for pro-BJP tweets and hashtags to demonstrate how commonly used this is as a technique to mobilize protest. The police don't appear to have clear answers, pointing mainly to the involvement of the Canada-based organization Poetic Justice in putting together the toolkit. The founder of Poetic Justice is a person called Mo Dhaliwal, based in Canada, who has professed his support for Khalistan. Hence, the police's somewhat overstretched claim that the India-based activists are supporting a Khalistani agenda.
Large number of hyperlinks are there. These hyperlinks are links to various Google Drives, Google Docs and websites. One of the important websites which is present here is askindiawhy.com. If you go to the site, you will find a lot of secessionist pro-Khalistan content present in that site. So this document in itself, from bare reading we can find there is an action plan, and when you go dig deep into it, and a person who is interested, who has been provided with this document, he goes through this document, that person can access all these data.
Also today, a new twist by the police, a claim of an ISI link. How? The toolkit recommends the names of many individuals to be tagged in tweets in support of the farmers' protests, including fact-checking websites and journalists. One of those tagged is apparently a foreign national who has been linked to the ISI.
तो सवाल ये है कि पीटर फ्रेडरिक साहब कौन है? तो इंडियन सिक्योरिटी एस्टैब्लिशमेंट इनको जानता है 2005-6-7 से। इनका नाम उभरा था, एक भजन सिंह भिंडर साहब है, बीएस भिंडर एलियस इकबाल चौधरी, जो आईएसआई की K2 डेस्क के बहुत पुराने प्रोपोनेंट रहे। उनके साथी होने की वजह से इनका नाम 2006-7 से इंडियन सिक्योरिटी एजेंसीज के रडार पे रहा है।
Imagine what a field day the pro-government media will have with this. Regardless, Disha Ravi is in police custody for 5 days, no less. The remand order from the Delhi Sessions Court cites as reasons the police needing to interrogate her over her WhatsApp messages which she has deleted, and also question her over links to this pro-Khalistani group. The same Delhi High Court order cited above comes to mind. It says that the magistrate, when considering a transit remand, must not grant it mechanically, that police officers should effect arrest only when they have reasonable suspicion and credible information. There must be definite facts as distinguished from vague surmises or personal feelings. All right, we've got a great panel. We have some of India's top criminal lawyers on the show. We have Rebecca John, we have Siddharth Luthra, we have Vikas Singh, and we'll also get around to Dr. Abhinav Chandrachud, who's Bombay High Court advocate and author of a book on free speech. But let me start with Justice Deepak Gupta, a former judge of the Supreme Court. Great to have you, Justice Gupta. What are your thoughts on the manner in which this arrest has been conducted? Other arrests are being planned.
I think it's an attack on free speech, an attack on the freedom of speech and expression. Every citizen of this country has a right to oppose the government, and as long as the opposition is peaceful. I've gone through the documents on the toolkit, those which are available on in the public domain,
Right.
and I see that there is nothing in the toolkit which says anything with regard to violence or anything with regard to inciting people. It does support the farmers' protest. It does tell them that they must move from Delhi, from the sites of the protest to Delhi and then go back. It doesn't say stay in Delhi, it says go back. There's nothing in this which talks of violence. This toolkit is much before the agreement between the Delhi police and the farmers' union, these protest unions had taken place.
Mm-hmm.
So I don't see what is seditious about this document. Not at all. It is, one may or may not agree with the protesters. That is a different matter. But to say that this is sedition is totally, I think, not understanding the law. The Supreme Court in as far back in many years back in Kedar Singh's case, where this validity of the sedition, the section 124A was challenged, it held that we are upholding section 124A because the expressions to the section make it clear that sedition can only take place where there is incitement to violence or to public disorder.
Yes.
I don't think this toolkit does any of these two things.
Right, that's the whole point, because it's not as if any...
I'd like to...
Yes, sorry, go ahead. Go ahead. Go ahead, sir.
If you give me 2 minutes.
Go ahead.
The sedition law was framed by an imperialistic, colonialistic ruler like the British Empire, which wanted to rule over India. Even at that time, the law of sedition in India made it a very grave crime, punishable with life imprisonment. But even at that time, as far as the home country, that is England, was concerned, sedition was only a misdemeanor, punishable with up to 2 years imprisonment. Now, as far as England is concerned, and Australia, many other countries, many other democracies, I should say, they don't have sedition on the law any longer. Or sedition is not a serious crime punishable with life imprisonment.
Yes.
I would have thought, with our experience of Bal Gangadhar Tilak, with our experience of Mahatma Gandhi being sent behind bars for sedition, we would have by now at least abrogated these laws, or at least toned down those laws.
Yes.
But unfortunately, these laws are being misused.
I
thought about this about a year and a half back when I gave a lecture in Ahmedabad.
Yes.
And I'm sorry, but now I find that it is being misused. And this, to me, is a gross misuse of the law.
In fact, there is now data which shows that it's actually ramped up. The number of sedition cases being filed has increased, and is being filed in a increasingly indiscriminate way. But I wanted to ask you, though, that, there's one thing to look at the police and their actions and to question that, but are you also concerned about the kind of judicial scrutiny which is given to these charges? Because at the end of the day, the police have to present it in court. And again, as in this case, was there a due application of judicial mind instead of just sending off this person to, 5 days of police custody?
It's all, in a way, I would not, I see many cases today, not only this young lady's case, but I see many other cases where the courts seem to forget that it is bail, not jail, which is the rule. And they don't seem to, at this stage, they don't even seem to read the documents. They just look at what the police asked them in a one-page communication that we want a remand, and that's all. I mean, I know a detailed scrutiny at this stage is not required.
Yes.
But at least they should apply their mind. This order shows total lack of application of mind. Because if the police has not read the Supreme Court judgments of Kedar Singh, I would have expected the judge to have at least been aware of that judgment.
Okay.
And in Balwant, there's another very important case, Balwant Singh's case, where in Sector 17 in Chandigarh, slogans were raised, Khalistan Zindabad and Raj Karega Khalsa. Even then the Supreme Court said, as long as those two slogans were raised, but there was no incitement to violence, this did not amount to sedition.
Okay. So those
That
are
is
the
not
precedents.
Beg
Right.
your pardon?
Those are the precedents which unfortunately are not being followed. Justice Gupta, thank you very much indeed for joining us and with your perspective. Thanks very much indeed. We also have with us Vikas Singh, Senior Advocate, Supreme Court, and Siddharth Luthra, also Senior Advocate, both, as I said, some of the top minds when it comes to criminal law. Let me just come to you first, Siddharth Luthra. What do you make of the manner and circumstances of this arrest, these arrests? Are they, as we just heard Justice Deepak Gupta say, basically an attempt to crack down on freedom of speech?
I think Justice Gupta has spoken about the merits, so I don't want to necessarily speak without having much information about the merits of the matter. The only concern that I must raise, though, is that yes, sedition is used too often, too hastily, and there is a serious concern. You can't just use it at the drop of the hat, and that's what the Constitution Bench had even said in 1962.
Right.
The only thing that's a matter of some merit, which we must consider, is that insofar as the production of this lady without being in Delhi, without being produced before a magistrate there, now what will have to be seen is, did the police have a warrant? If they had a warrant, then they were duty bound to produce her before the magistrate in the local jurisdiction and then bring her to Delhi. However, if they don't have a warrant, and that's a view the Delhi High Court took way back in 2014, that's a view they took, division bench of the Delhi High Court, that as long as you produce a person within 24 hours, there is no necessity to produce before the area magistrate, which really means that the person, and that's the law declared, at least in Delhi. There was a different note taken out in a subsequent decision in Gautam Navlakha's case, but then that matter went to the Supreme Court, and meanwhile there was a stay, and therefore the issue of law was left open. So really we have to go back, and as of now, the valid judgment is really the 2014 decision.
Okay.
So you have a difficult situation because this 24-hour rule, which is the constitutional parameter, which is Article 22, as also under Section 57 of the CRPC, is technically complied by producing the person within 24 hours, excluding the time of travel. But what is more important is, did the person have access to a lawyer? Did you comply with the formalities for arrest? And I think the larger issue which we all need to address is, are the rights of a detainee or an arrestee increasingly become only paper rights? Because that's what gives you the right to access justice.
Fair enough.
If she had access to a lawyer, she would have then said, I want to be produced before a magistrate so I can argue for transit bail. So these are the issues which we need to consider, and that's becoming a serious procedural and human rights issue.
Issues that come up. Before I go to Rebecca John, let me just bring in Vikas Singh as well. Vikas Singh, is there also something about this arrest, similar arrests also planned in this whole toolkit business that is of concern to you?
Well, according to me, this is clearly showing that the state is becoming extremely intolerant to dissent. Now, if you see the Constitution Bench judgment of 62, when they decided what should be sedition, actually then the question of sedition being ultra-virus was being considered as to whether it violates the right to free speech. Now, it was held to be not ultra-virus, only with the caveat that you can bring in sedition only when there is a direct attempt to incite violence. Now, here definitely this girl can't be said to be directly involved in inciting violence. Number two, when you talk of free speech, this right of free speech under our Constitution actually is not being conferred to the press, as is done in the US. And to the citizen. Here it is given only to the citizen of India. So every citizen of India has a right to free speech. And that right to free speech will definitely go to retweeting something, or if you agree with something, then go ahead.
So therefore,
there is no direct evidence which has come in the public domain to suggest that this girl was, in any manner.
Okay, let me come back to all of you in a second. Let me just go across to Rebecca John, who I spoke to earlier, about her views on this entire case and the manner in which these arrests have been done. Rebecca John, now, you've put out a post where you've been very critical about the manner in which all of this arrest and all that was conducted. You perhaps had a chance to hear the Delhi police. They say that all rules were followed, but you remain unconvinced. What exactly are your problems or issues with the manner in which all this was done?
Yes, Srinivasan. Now there's a lot of fact and there is a lot of fiction. So let's try and separate them. Fact, this young woman was arrested on Saturday evening. Fact, she was produced before a magistrate in Delhi yesterday, that is Sunday, in the afternoon. Fact that a legal aid counsel was present at the time of her remand, not her counsel of choice. Fact, she was remanded to police custody for 5 days. Now, I am critical of this for the following reasons. I oppose weekend arrests and productions. I believe the Delhi police could have waited for a Monday arrest and a Tuesday production. By producing an accused person on a Sunday before a duty magistrate, you're basically ensuring that her legal rights are compromised, because it is very difficult for lawyers to be present. Most lawyers don't even know that their clients are going to be produced in court on a Sunday. Secondly, in this case, it appears that the Delhi police did inform her lawyer of choice. However, I can tell you from my experience of being a criminal lawyer in Delhi for the last 33 years, there is this cat and mouse game which constantly happens between the police and defense counsels, where defense counsels are never really informed about the time and place where the production will take place. And I think that confusion took place yesterday as well. And that is why the lawyer of choice could not be present. And that is a serious problem. Now, once you've informed a lawyer of choice, there is no reason why the court could not have asked this young lady whether she wanted that lawyer of choice to be present, and information could have been sent that we are now commencing remand proceedings. These are not difficult things to do. This happens every day. One. Number two, the manner in which she was brought to Delhi is also problematic. She was arrested in Bangalore. And while I completely agree with the Delhi police that there is no mandate that a transit remand must be taken from Bangalore to have her produced in Delhi, but it is the spirit of the law. So they have not violated the letter of the law, but they have certainly violated the spirit of the law. And I would like to remind the Delhi police that there is a December 2019 division bench judgment of the Delhi High Court, and the Delhi police is bound by that, where in exactly similar situations, the Delhi High Court laid down guidelines for production of accused persons from outside the jurisdiction of Delhi. And the Delhi High Court stated, and I quote, "The arrested person must be given an opportunity to consult his lawyer before he is taken out of the state." Was this done? Perhaps not. Two, endeavor should be made to obtain transit remand after producing the arrestee before the nearest magistrate, unless exigencies of the situation warrant otherwise. Was this done? No. What were the compelling reasons that you did not produce this young lady before the appropriate magistrate in Bangalore? And if there were compelling reasons, did you inform the magistrate in Delhi that this was the reason why we did not obtain and get transit remand from Bangalore? Another problematic aspect of this whole case. And the Delhi High Court goes on to say that the magistrate before whom the arrestee is produced must apply his mind to the facts of the case and should not grant transit remand mechanically. He must satisfy himself that there exists material in the form of entries in the case diary that justifies the prayer for transit remand. So the Delhi High Court is in fact reinforcing the fact that if you are arresting someone from outside your jurisdiction, you must take transit remand, and you must at least put forward your case diaries before the transit magistrate. And
so that is
cases made out of transit remand.
So that is the problem with the absence of the transit remand and the manner in which she was brought from Bangalore to Delhi, and also, as you mentioned, the problem with this whole weekend arrest business, which leaves the lawyer in the lurch, so to speak, that you're not able to get that information, you're not able to be there. But let me also ask you about the fact that she was ultimately then remanded or sent into police custody for 5 days by a court here in Delhi. And in the remand order, the court says that the police, justifying their need for police custody, say because they wanted to recover material from a deleted WhatsApp group, and other devices and mobiles, that for proper investigation, her detailed interrogation is required to get information by the pro-Khalistani group and their active members and so on and so forth. Are these, without getting into too much of the nitty-gritties, are these justifiable reasons to remand a 21-year-old for 5 days to police custody?
Now again here, Vasu, there are two things. The law allows the magistrate to remand an accused person to police custody for a maximum period of 15 days in the first tranche. So remanding her for 5 days is not an illegal order. So we are not talking about illegalities here. I'm talking about proprieties. My entire conversation with you is about propriety, not illegalities.
Yes.
Now, was it right for the magistrate to remand her for 5 days at a stretch? I would say that it would have been better if a duty magistrate, if he felt that there was a case of remand that was made out, remanded her to 1 day's police custody and asked her to appear before the regular magistrate on a weekday, that is today, 24 hours police custody to be reviewed today. That should be the proper thing to do. If you remand somebody for 5 days at a stretch, you really do not have the kind of monitoring that is required, and perhaps a regular magistrate who is seized with the matter would be in a better position to do that monitoring.
Right.
So if a regular magistrate had remanded her for 5 days, maybe it was not so questionable, but I do believe that duty magistrates must be circumspect when they remand people for 5 days police custody at a stretch.
Right. Okay, Rebecca John there. Let's get the last word in from Abhinav Chandrachud, patiently listening in. Abhinav Chandrachud, you've been, of course, part of this ongoing conversation on free speech. We were speaking about it earlier in the context of Tandav, and now you have these, sets of arrests. What do you make of it?
I of course don't want to comment on the merits of any ongoing case, but let me just tell you about one of the sections which seems to be a section that the accused has been charged with, which is sedition. Now, my request to the authorities, to the powers that be, is please consider bringing sedition on our statute books, on the Indian Penal Code, in line with what the law was in England in 1832. Of course, we get our law of sedition from England, where it has been abolished since 2009. But in 1832, sedition in England was considered a misdemeanor that carried a sentence of 2 years in prison, whereas on our statute books, it carries a term of life imprisonment. In 1832, sedition was considered to be what is referred to as a non-cognizable offense. In other words, the police can't arrest you without a warrant from a magistrate. They can't investigate the case without a warrant and order from a magistrate. Whereas today it is a cognizable offense. It was made so by the Criminal Procedure Code of 1973 during the regime of Prime Minister Indira Gandhi. Now consider for a moment what that means. When Bal Gangadhar Tilak was charged with sedition, he couldn't be arrested unless the police obtained a warrant from a magistrate. Whereas today in independent India, our citizens of this free and great country can be arrested by a police officer without a warrant from a magistrate because it's a cognizable offense. And finally, sedition in England in 1832 was a bailable offense. That means if you were arrested by a police officer, you were entitled to be released on bail as a matter of right. Whereas today on the statute books, it is a non-bailable offense. So please bring sedition in line with what the law was in England in 1832 if you don't want to go to the extent of abolishing it.
Okay. Fascinating point, Abhinav Chandrachud, but we're completely out of time. Thank you so much for joining us, and thank you all so much for watching. That's all the time we have. Good night.